time, 1 minute early. We're going to start 1 minute early. Oh, fine. You were pointing the finger at me, not just, okay.
I like to flip that finger in here.
Okay. Committee, we're back in for this afternoon. Thank you for being back here on time. We're into where we would hope to be on number 3 on looking now at vulnerable adults. You'll see on the agenda, we talk about the civil cause of action, which we had talked about in the meeting in Lander. Senator Nethercott, I'm going to ask you to opine just a little bit, as much as you feel that you want to on this. You'll recall the task force has got the ability to recommend this to a standing committee or as a personal bill, and Senator Nethercott has agreed to take this on as a personal bill. And so I'm just curious if there's any further information you want to provide this committee, or tell us how we can assist you in the work, and then we'll go from there.
Thank you, Mr. Chairman. I have agreed to take this up as a personal bill this next legislative session. As the committee may recall, this is I think an incredibly important bill that addresses a gap in our legal system in Wyoming, allowing for a civil remedy for the exploitation of vulnerable adults. And what this bill draft really does is it identifies who can bring that cause of action on behalf of a vulnerable adult. And so we've gone through this bill draft before, and so I won't use the committee's time to do that again here. But the assistance that you can provide is continuing to communicate to your constituents and to legislative colleagues about the importance of this bill, which purpose really is to protect vulnerable adults and provide a judicial remedy for that exploitation. So that it isn't litigation, that it isn't something for lawyers, it really is to protect some of the most vulnerable in our society and in our state. And so really important bill, and look forward to carrying it this next session.
And committee, I think it's important to know now that she carries it, it's her bill, and so she's certainly got the latitude to maybe adjust language or make corrections where she feels is appropriate, and look forward to seeing that end product. Okay. I'd like to turn my mic. Would like to move on then to guardianships and conservatorships in 24 LSO 0192.6 version 6. It is. This is a conversation we had, I believe, in Lander as well, and there was some concern amongst the task force on the need for the bill. You'll recall that the bill came to us at the recommendation of one of our district court judges who had identified a problem and a challenge. We held off on moving that bill in Lander, and then our good committee member Elise has come back and reviewed our thoughts and our comments, and you should have all received in your emails some further information from her and some recommended changes to the bill. They feel that this still has there's still a need there that we ought to address. And so, Elise, if I may, can I turn this over to you, and if you'd walk us through your considerations and your recommended changes, and then we'll contemplate working that bill.
Thank you, Mr. Chairman. So if you all remember, the reason for this bill, I think, is twofold. And the first is to ensure that guardians and conservators are filing annual reports. And that's a statutory requirement. Quite often, the judges have a difficult time getting those reports from guardians and conservators. And really, it's a mechanism to ensure that the ward is being protected and that the actions taken by the guardian and conservator are appropriate. The second reason is also to ensure that people who may have previously been appointed as a guardian or conservator aren't using outdated letters or orders to prove that they are in fact a guardian and conservator, and when perhaps that guardianship or conservatorship has been terminated. And so this bill draft is really aimed at those two goals. I had the opportunity to talk with Judge Donessa Steiner, who's a district court judge in the 2nd Judicial District, and Emily Smith, who's the executive director of the Guardianship Corporation, just to get a better understanding of whether or not we think this bill will be effective and helpful in those manners. I know we talked at the last meeting about, what is a letter going to do that an order would not do? If you have a current letter of guardianship or conservatorship, does that make any difference when you have the original order? So we talked a lot about whether or not this was still a good idea, if there was any way that it would be effective, and the consensus was that yes, it would be helpful, probably much more helpful in conservatorships, and I'm probably going to step outside my lane here. So Emily Smith is here today to answer any questions, I hope. But it's my understanding that with conservatorships, most financial institutions actually require letters of conservatorship in order for a conservator to act on behalf of a ward. And so for those circumstances, it would be incredibly helpful to have a letter of conservatorship that is updated every year and has a current date on it, so that when that financial institution receives that letter, they know that it's actually current, or not less or not more than a year old. And so what this bill does is it requires the conservator and the guardian to file their annual report. On the filing of an annual report, they will receive a letter of guardianship or conservatorship that can then use for that next year to prove that they are in fact a guardian or conservator. And each year annually, there will be an expiration date on that letter. So they will stay up to date. Hopefully will encourage guardians and conservators to update their annual reports as they're required to do. So there were a few changes, though, also as a part of that. And Mr. Chairman, I don't know how you would like me to walk through that, or if there are additional questions on the purpose.
So what I propose we do, Elise, is maybe ask Emily to come and give us her public and anyone else public comment on that. But I think proper order then would be to, upon hearing that, in looking at the potential changes in the bill, to then work the bill, and in the process of working the bill, because it's still shown as version 6, to amend that bill with the changes that you feel would be appropriate, and then to, okay? Emily?
Good morning. I guess it's the afternoon. Good afternoon. We can all tell because it's hot now, and this morning was freezing. I'm Emily Smith. I'm the executive director of Wyoming Guardianship Corporation, and I'm here to voice Wyoming Guardianship Corporation's support for the bill. Just to piggyback a little bit on what Elisa said, in the case of almost all financial institutions, banks, investment companies, insurance companies, they already require, they're going to ask for your letters. Even, and I was just speaking to a couple of my staff a minute ago, even for guardianship, even though guardians wouldn't be managing money, in order for the guardian to see what if somebody has an account, to look at bank accounts, to, do anything that would have to do with a banking institution, they're going to require the letters of guardianship. So for conservatorship, it's very helpful. For guardianship, still helpful to be able to provide those letters, or that the institutions are asking for those letters. I also understand that the Department of Health, and Director Johansson could speak to this maybe, is starting to require guardians to provide updated proof of guardianship so that we don't have situations that Elisa talked about where we have guardians who their guardianship has changed or terminated years ago, but they're still providing an order that's old, and it's very difficult for people to tell if that order is, if it's from 2001, is that still in effect? And so the updated letters every year will provide an opportunity for everybody to know and understand that the guardianship is current, which I think is really important. Because some of these letters, some of these original court orders are from the 90s and the early 2000s. And so how do you know that all of those conditions still existed if you don't have an updated document to look at? The other part that I think is really important about this bill that we support is, excuse me, that if the guardian is not filing their reports in a timely fashion, that now our judges are able to remove them as a guardian and appoint someone else, because that previously hasn't been a thing either. And I know the original language was just that the guardianship terminated. This is much better language because the guardianship, the conditions that necessitated the guardianship or the conservatorship still exist. So we don't need to terminate the guardianship or the conservatorship. What we need is a guardian who's doing their job and a guardian who's doing a good job as a guardian and conservator. So we really support that language in this bill as well. And if you have any questions for me, I'd be happy to answer.
So, committee, any questions regarding the bill?
Okay.
Or for Emily, not particularly the bill, but any questions for Emily? Okay, thanks, Emily.
Thank you.
Appreciate you being here. Any other public comment? Public comment? Okay. Committee, what's your pleasure? Moved by, seconded, so moved and seconded. Discussion on the bill? Oh, okay, we got all that, okay. Any comments? There's concerns on the bill last time. As we worked the bill, some amendments to be made. Do these changes in the bill resolve concerns that we had in the committee last time?
Mr. Chairman, I actually,
Oh,
Senator Barlow.
Senator Barlow, thank you.
Thank you, Mr. Chairman. Maybe I missed some, but I think Ms. Butler was going to actually go through some amendments. So we could make comment at that time. Is that accurate?
That is.
Okay, thank you. I'll withhold. Thank you.
Okay, thank you. So let's work the bill and we'll propose the amendments as they come and discuss those changes. So it appears to me that our first change in the draft, or the amendment in the draft, would be on page 2.
Mr. Chairman, that's correct. So the amendment would begin on line 3 of the original bill draft. Upon the appointment of a guardian and the comma, we would add language that says, and the filing of an oath by the guardian, comma.
And filing of an oath, comma, right? And
Yep,
then,
and Mr. Chairman, it's a little bit different than the draft that you have in your materials based on some comments that I got from Senator Barlow. So what it would say is, upon the appointment of a guardian, comma, and the filing of an oath by the guardian, comma, the clerk of district court shall issue a letter of guardianship for a period of 1 year that may be renewed annually with the filing of a guardian reports pursuant to WS 32109.
so the new language would be, and the filing of an oath, comma, by the guardian, comma.
Yes.
And would that be the same down on line 10 and 11?
Yes, on 10 and 11, it would be the same with the substitution of a conservator rather than a guardian.
Could we make that one amendment?
Yes, Mr. Chairman.
Second? Okay, discussion? Senator Barlow, any comments, Eric, on this one? Okay. Those in favor, aye? Aye. Opposed? Okay. Moving on.
Mr. Chairman, the next amendment would be at the bottom of page 2, and that would be to strike lines 22 and 23, and then on to page 3, lines 2 and 3. And then to replace that language, insert Romanet 4, which currently exists in statute. And that provision says a determination by the court that the guardian or conservator is not acting in the best interest of the ward. And then after that, this is the new language, a comma, including failing to file a guardianship report pursuant to WS 32109, or failing to file a conservatorship report pursuant to WS 33901, period. And then the rest of the language is there, it exists today, and it says, in such case, the court shall appoint another guardian or conservator.
It's been moved and seconded. Discussion on the amendment? Question on the amendment? Those in favor say aye. Those opposed? Further discussion on the bill? Roll call. Oh, Eric, or Senator Barlow, sorry.
Thank you, Mr. Chairman. So I do think that we should probably actually have a little discussion on the effective or section 2. And this is the application of guardianships and conservatorships first created on or after. And what I guess I want maybe our legal staff to tell us is, it looks to me like the way I read it is, no guardianship or conservatorship that's already in place would be this law, this change would be applicable to. Is that accurate? And if it is accurate, then maybe we should rethink about that, that created word in some way. So anyway, I want to clarify if that's my understanding of it. And I apologize, Ms. Butler, I didn't bring this to your attention, but when we were having our discussion, but I just want to understand if that first created. Because to me, there is that means that nothing that's already in place would fall under this new law.
I would agree with that. And it appears to me that we would just want to say that the act shall take place, that it goes into effect and applies to all guardianships and conservatorships on July. Is that the intent, Elise?
Mr. Chairman, yeah, I think that's right. I apologize, I didn't catch that, but I think that's right. I think we would want it to apply to guardianships and conservatorships that are in place now. And when they file their next annual report, they'll get a new letter with a termination date on that.
Senator Barlow, would you have a proposed amendment for that?
Mr. Chairman, I think the simplest is to strike section 2 and renumber section 3.
Okay. That's a motion. Is there a second? Question or Shara?
No. Question.
Question. Motion strike section 2, renumber section 3 to section 2. Those in favor, aye? Aye. Those opposed, if any? Any other comments?
Mr. Chairman,
Please.
so that particular amendment creates, I think, a logistical challenge for the court, of which Ms. Butler identified a solution for how the court would handle that. Just a conversation about more clear direction about the court's implementation of that. So for example, there are thousands of conservatorships and guardianships currently in place right now in the state of Wyoming. Randomly throwing that out there, but I feel fairly confident. There are thousands. So the court is not going to automatically just issue letters to all of those right now. And so Ms. Butler indicated that at the time of their annual report filing and or the acceptance of it, the court would then issue those letters at that time. I just wanted to thoughtfully think that through for the court's benefit, so the court knows what to do. And those that are guardians and conservators in this state understand that that's how it will work, because the statute doesn't outline that process. So it's a logistical challenge associated with the current guardianships and conservatorships in place and their letters. Everybody following me? Am I making-
Senator Barlow?
Nobody's responding.
Thank you, Mr. Chairman, and I certainly do appreciate Chairman Nethercott's perspective and caution on this. There's probably two things. One is this bill has to go somewhere. It's either personal bill or it's something we work with the courts to try to understand how that gets communicated, implemented. The second part, when maybe it's both, is that we extend we make the effective date January 1st of 2025, so that we have much more lead time before it becomes effective. But I do think, based on the discussion we had about it not applying to any current guardianships, the thousands that I think was referenced by Senator Nethercott, thousands that may be out there, it seems like we're going to leave a big gap with the purpose of this bill if we don't actually make it applicable to everyone. So let's try to find that place where it's more time, more education, and the court working out that process. And maybe that is just making the effective date January 1st, 2025. Thank you. As a suggestion. Thank you.
So my question then, and I don't know who it's to our legal minds and the court, with the logistical challenge, if we move that effective date a year, do we need to give the court's instruction in the bill to inform, tell us how this would work? If we're giving them an extra year, there's nothing that requires them to provide notification, right? Senator Nethercott?
Mr. Chairman, as I kind of think it through with Ms. Butler, I don't think it's necessary to extend the effective date. That's not the challenge with the circumstance. The triggering effect for the current conservatorships and guardianships in place would be the time of filing their annual report, which is dependent on their each individual case. And so it's going to be rolling throughout the year for each of them. Until that time of filing their annual report is done, they won't receive letters, right? The court isn't going to go look at it. I mean, the court could, but the court will not look into its file and see all of the conservatorships and guardianships in place and then issue letters automatically. That would arguably also be somewhat inappropriate. You'd want to wait until that annual report was filed, and then at that time, the court would issue the letters at that time. So it may be, I don't want to add something in statute that's very temporary in nature. So it may be fine right now. And we'll ask the court about implementation of how it's going to look. And I won't take the committee's time with that right now. It's a more logistical side for the court. And then, of course, all the financial institutions that may now be expecting these letters, that people who do have had a conservatorship in place for 20 years, for somebody has no idea what the financial institution's talking about and is frustrated because they've been doing this for 20 years and now all of a sudden they need letters that never existed before. And so how does that work moving forward? And there'll just be some education about that. I don't anticipate it being an overwhelming concern because, again, it's on that rolling basis, each annual report being due on the date that original conservatorship was created. Disregard. Thank you.
Thank you. Elise?
Fix it later.
Mr. Chairman, it would make sense to me that with the new statutory change, it would be, they would get letters at their next annual report. But we will make sure to vet that through our judges and ensure that everybody's on the same page. I don't think I would agree with Senator Nethercott. I wouldn't recommend any other language be added.
Hey, you good? Katie, roll.
Mr. Chairman, this is Task Force Roll Call for 24 LSO 0192, Guardianship and Conservatorships, Letters and Termination as amended. Senator Barlow?
Aye.
Senator Nethercott? Representative Summers?
Excused.
Representative Zwaniter? Co-Chairman Larson?
Aye.
Co-Chairman Baldwin?
Aye.
Director Johansson?
Aye.
Director Schmidt? Aye. Deputy Director Babbitt? Dr. Ballard? Aye. 9 aye, 1 excused for committee recommendation.
We'll have a conversation on where we're going to send this. I'm not quite sure. Judicial just really does have a peach basket full of bills that they're working on. So we'll get it sent to a friendly committee. Appropriations, I guess that's the only friendly one left out there. Okay, let's move on then to, if I can find my, anything else on vulnerable adults that we need to bring up before we move on to the adolescents with high behavioral needs? Anna?
Mr. Chairman, you have a note here to talk about Adult Protective Services budget requirements. That's on the agenda for whatever reason.
Yeah. Corin, well, and I don't expect you to have a definitive answer, but have you contemplated anything in your budget to, in your APS unit? I've not seen, maybe I have seen.
Mr. Chairman, no, not at this time. We haven't contemplated anything other than positions.
Okay. Okay. All right, we're going to move on then to, and what we'd hoped to do with the adolescents with high behavioral needs, and Director Johansson, Director Schmidt, I'll kind of leave this conversation up for you. That's nothing really formal, but if you could just kind of bring us up to speed on the process on the RFI and any contemplation in the event, are you getting how, once you receive those back, if you think that is the fit, how would you make that recommendation then going into is that something you'd try and do in this budget cycle? How would you anticipate that if the RFIs came in and not necessarily needing to know what that is, but just when that is, and how are you going to try and do it in your budget request, or how you would, just where we kind of have a feel?
Mr. Chairman, if it's okay, I'll go first and then I'll let the director speak. In regard to the actual RFI, the RFI is due on Monday, October 9th. To date, we've received one. We will be discussing it with Dr. Ballard, Director Johansson. I think on October 17th is when we'll get together and certainly be able to look at what that cost is. We really haven't had a conversation internally about what to do with funding. I think at least my approach was to see what it is that the ask is, and then make some consideration about whether this committee needs to hear that and understand it, or internally we can decide what the best way is to approach that. In regard to the conversation about Plan B, which was what we discussed in the last committee meeting, I'll pass that over to Director Johansson to address.
Can I just ask a question? So you potentially have several sources of applicants, if you will, on the RFI. So would would that influence where the budget request would be coming from? And so if it came through, would they all come through you? But if they come, for example, if they came through a BOCES or an RTC, a PRTF, would that impact whose agency would look at that versus if it come from a community mental health provider, or is it all, tell me how that works.
Well, Mr. Chairman, we really didn't have that explicit conversation, but just based on traditional ways of funding, I would expect that if it comes through a traditional youth services advisor type or youth services association type provider, somebody that's already enrolled with us as a provider, we would take on that budget. So that would be group home, crisis center, that kind of organization. If it's a community mental health or substance abuse center, potentially it would go through the Department of Health. The way, though, that those dollars we would anticipate managing them is the same way we're managing our interagency children's collaborative dollars, which is a joint approach between Department of Education, Department of Health, and Family Services that makes those decisions on a case-by-case basis, and then we blend the funding through that. So right now, the ICC is working from ARPA funds that were appropriated through the legislature. They are in the Department of Family Services budget, and then through the collaboration, we make decisions and then execute the payment.
So then, with that breakdown between those three agencies, even still scratching my head just a little bit to understand how it works, because we would, if I'm hearing you right, you still anticipated that education would take care of education. You guys take care of medical. In those circumstances, Warren, you guys take care of some of those services. And so then that may be kind of is there any thought that that's kind of this collaborative budget request? Is that kind of?
I think, Mr. Chairman, if I may, I think it really depends on what the proposal suggests, and then we'll have to make some determinations based on that. So if it's a community-based type service approach, that may look very different in a budget request than it would be for an all-in one rate per kid type approach.
So is the takeaway here, chill out, Lloyd, and let's see what they find out?
Mr. Chairman, I think that's what Director Johansson would say.
I think that's true too.
Mr. Chairman, I would just say the legislature needs to stay out of our executive branch business and how we spend the
Fair
funding.
enough.
But no, to add to what Director Schmidt said, I'm not all that concerned yet about the mechanics until we see there's ways to execute this either through one budget, or we've gotten pretty good at executing MOUs over the past couple of years to braid funding, that type of thing. So that is not a huge concern. What I'm really looking to see is, as Director Schmidt mentioned, do we see a large proposal or a very small proposal, one that encompasses all the residential or just the support services? That will really help determine which budget is most efficient to put it through. Having done the RFI, I think we're in a good place when it comes to how the state can procure things through all the requirements and rules. And then to Director Schmidt's comments about the Plan B, we're certainly ready to execute that. The challenge that I mentioned in Lander, or at our meeting in Lander at the Life Resource Center, is still very much present with our staffing situation at the facility. However, in working with A&I and others over the past couple of months, we have some proposals and some steps forward that I'm optimistic will improve that staffing situation in the hopefully, knock on wood, in the short term. So as Director Schmidt mentioned, we'll gather after all of the proposals come in and chart a path forward. In terms of the mechanics of if we see a larger budget request being needed, given where we are in the 25-26 budget development, certainly don't want to get out in front of my skis or in front of my boss. We could brief during our budget hearings on options there that could be per the Appropriations Committee discretion, an amendment or a bill or a footnote, or we could certainly have discussions about a last minute exception request or a governor's letter if that would be preference of the executive branch, but some of that is still TBD.
Okay. Questions, committee? So if I may, before we go on and ask Elise to just update us on the diversion pilot program, is I continue to field a number of questions regarding group homeless crisis beds, RTCs and PRTFs. Are we talking about rate rebasing and things of that nature? Had a couple yesterday from legislators, and so in this meeting, as others are watching, and I'll ask Director Schmidt to just confirm the accuracy of what I'm saying, is that that conversation which has been going on between the Department of Family Services and those providers for adolescent mental health services has gone on now for a period of time, meaning over the past couple of years, but then we requested and got a rate study approved. That study, I think, is preliminarily complete, but has not been released in its entirety, but we're making progress on that to kind of see how those different sources of services look in that study. So would you clean up my mess and please, Director Schmidt?
Mr. Chairman, no, I think you're pretty much on target. The Department of Family Services hasn't analyzed the rates for our congregate care providers since prior to 2016. In 2016, the department reduced its budget, and part of the 2016 budget reductions eliminated the annual rate analysis or the periodic rate analysis. Shortly after 2016, we cut rates we cut our budget in 2020, and therefore there was never any reason to do a rate analysis when we're in fact reducing rates. Part of the appropriation then in the supplemental budget this year was some additional funds. We were able to engage with the same contractor that's used by the Department of Education and the Department of Health to do rate analysis. We do have preliminary results. We were waiting on one last provider who has now turned in their information. We'll be having an internal meeting in the next week or so. We expect the final results sometime next week. We'll have an internal conversation first about what that says and means in terms of the methodology, and then a discussion after that.
Thank you. So those of you impacted by that, and those of you who have constituents or providers watching this, I hope that provides an update. So moving on, we're on, well, let me ask any questions on that topic. Okay. Moving on, thank you, we're catching up on our time. We had contemplated having some further conversation on CIT training. I think we're going to move that to the next time. And so I would like to ask Elisa if she could just bring us up to speed on the work that they've been doing in Gillette on the pilot program and where that stands.
Absolutely, Mr. Chairman, happy to do it. So the work on the diversion pilot program in Campbell County continues. A group of stakeholders has met a few times over the last few months to come up with the structure of that diversion program, and then also to put some foundational documents in place, a handbook, standard operating procedures, those kinds of things. If you all remember, the diversion pilot program is aimed toward diverting low-level offenders with serious mental illness away from the justice system and into treatment. And so the model that we're using, or we will be using as part of that, is what we do in the treatment courts. Treatment courts right now are post-adjudication, so you have to go through adjudication in order to be diverted to a treatment court. And they are generally, although not always, they are generally geared toward felony offenders, so you avoid jail by going into treatment court. This is a little bit different because it would be pre-adjudication. So somebody is commits a low-level offense, trespassing, and pre-adjudication, that offender would have the option of being diverted to treatment and the treatment court model, rather than having to go through adjudication. So work is continuing. The goal for launching the pilot would be first or second quarter 2024. I know I am not the one leading the charge from our office on this. It's Ben Birmingham, who is also our Chief Legal Officer and Director of Chancery Court. So he wears many hats, but he's working very hard with all of our stakeholders, including folks from the Department of Health, some judges up in Campbell County. I know Senator Barlow has been very involved in this project, prosecutors, public defenders, treatment court folks. So we're working hard on getting all of that stood up with the goal, like I said, of piloting in first or second quarter of 24.
Thank you, Lisa. Anybody in the committee have any questions? Senator Barlow, are you still with us? We don't see his picture. All I see is me on the screen. Any comment from the public about that report, since Senator Barlow apparently has left us? Just like Elvis, he left the building. Okay, Mr. Chairman, back to you.
I left but felt guilty and come back. We have the ability to have conversation on our CIT issues, and so you recall what we had talked about was to determine whether the CIT training was something that we needed to secure funding for, if there is a desire to expand that, kind of how all that is. Mr. Thompson, Alan Thompson with the Association of Sheriff and Chiefs of Police is here. And as I stepped out, he's agreed to come up and give us a report and their recommendations on maybe how that would look. Alan, thank you.
Mr. Chairman, thank you. My name is Alan Thompson with the Wyoming Association of Sheriffs and Chiefs of Police. And I've been working on some homework assignments that I'd received from our last meeting. And, I'll start with, before I answer some of those specific questions, what we've been doing for the last month is working on the statement of work specific to that CIT grant that we're operating under right now, that provides reimbursements and a portion of that to provide training. We hope that will be finalized in the next couple of weeks. And if it goes through, then it's going to fund up to 6 training programs for train the trainer and coordinator for entity or individuals from across the state to receive that CIT training. Likely in Salt Lake City is the closest one.
And that grant application is to whom or to where, or what's the source?
The grant application is a current grant that WASCOP has with the Department of Health,
Okay.
the Public Health Division of the Department of Health.
If I may, are those ARPA funds?
Mr. Chairman, I believe so, but I'd have to double check.
Okay.
And that funding, Mr. Chairman, does go through June of 2024. So we don't anticipate any ask from WASCOP's purview for CIT funding in the 2024 session until we get a better idea. It'd be after that session, because part of that funding has been reallocated to put together a statewide training, and part of that training will be forming an association or a consortium to kind of warehouse that data for CIT. I have been working on gathering data from across the state. So far, I've had 23 of our 83 agencies report back their CIT training or certification. And what it shows is 388 of the 763 positions in agencies that did report, no, not all agencies reported, but of the agencies that did report are CIT trained on the peace officer level. So that's a 51% return on that. But if you take the total number of peace officers in the state of Wyoming, that would be around 23%. So even assuming that all of the people that haven't reported yet have no further CIT training, which I know looking at the list is not accurate, the minimum number of peace officers that we have trained in CIT in the state of Wyoming is 23%, which I think is pretty admirable, considering we've only reimbursed 151 positions under this existing grant. So that's work that's been done by the agencies for previous years with an additional 151, just during this last year and a half. And then, so that moves into that forming of an association or a consortium of sorts I think we're getting interest from our membership across the state. It looks like we will have interest in people attending that training program as a kind of a CIT advanced training or continued education component of that. So we're not just providing this 40 hours of training to our officers, dispatchers, and detention officers, and then 20 years down the road, there's no follow-up on that. So I think we're heading in the right direction, and I think we'll know more about the needs of CIT in the state of Wyoming as we put this association or consortium together.
Are you reaching out to tribal law enforcement?
I have not specifically reached out to tribal law enforcement.
Could I make that request of you to do that? I can give you a name if you need.
Yep.
Need one. It's Eric Blackburn, but I can get you that contact. They have not had CIT training and had expressed interest to participate if that would be allowed. And my understanding is there's nothing that would prohibit us from helping and allowing them to participate. That'd be great. Okay.
Mr. Chairman, I'd be happy to answer any other questions.
Questions? Committee? Very good. Thanks for following up on that. Job well done.
Thank you.
Okay, committee, are there loose ends before we ask LSO? Anna?
I think you forgot to ask about public comment for adolescents with high behavioral needs and for this topic.
Yes, I did. Let's go back to adolescents with high behavioral needs. Are there any public comments? And I apologize to any of those that, and who else did I forget? Oh, CIT on the diversion part. Okay. Whew. Okay. Anything? If the committee, and I know that we're nigh into October, I don't know that we'll get everything completely done by this session, but I'm not 100% convinced that we're where we need to be or should be on this K-12 conversation on really providing a definitive answer. So, I'd like to sit down with my co-chairman and kind of play with that a little. And I think there's more work that we need to do on that. Mr. Chairman?
Yeah, Mr. Chairman, I would submit that maybe we need to get some more comment from our administrators, from more folks with their feet on the ground in K-12, and then go from there. Take some of that input and take some of their suggestions. Maybe let them listen to the minutes of this meeting and what we've done and get more suggestions, and you and I can talk and see where we need to go from there.
Okay. No, and I think that's fine. I just think that in part of this process, as we gather this information, I think that we need to understand the services that are available, the services we're looking to provide, how all of that. I don't think it's as, there's maybe a little more complexity to this than we do. So we'll work on that if you guys will bear with us for a while.
Mr. Chairman,
Yes.
I might just mention Chairman Baldwin's Labor Health Committee did pass the two bills that this task force referred on, one relating to behavioral health redesign the other vulnerable adults being part of the behavioral health redesign priority population group. So those passed as committee bills in case folks weren't tracking.
Did I understand that there was sunset dates put on those?
Mr. Chairman, on one provision that would go into the statute, one Romanet has a sunset date on it, as I understand it. So it's interesting, it's workable, but the discussion was really taking a look at if those changes were made, which they ultimately were recommended by the Labor Health Committee, to essentially re-review that in 2 years' time.
Oh, okay.
And I think actually, Mr. Chairman, that will have very little effect on the building. We discussed that at length, and we haven't decided which house those will go to yet. We will, Chairman Vonter and I will discuss that.
Thank you guys for doing that. Anything else for the good of the humanity and dogs as they roam the streets of Cheyenne? Okay, with that, I think we're adjourned. Thank you all.